Watwanumeradu Ziwagwego. Welcome to the formal reading for the final Kahnawake Residency Law. At this point in time, it's important to mention that there will be no further substantive feedback that will be accepted. The hearings are complete, so that means that if there are any corrections during the reading of the law into the record, incidental amendments such as spelling, punctuation, grammar, or there could even be a change in the format of the law itself. The law will be read into the record in its entirety by Ietséhaienhs Tonya Perron, Ietséhaienhs Kahsennenhawe Sky-Deer, Trina C. Diabo, and Alan John Rice. The certification of the process will be signed once the law has been read into the record. The enactment is scheduled for June 17, 2019. So because the Kahnawake Residency Law has been categorized as a Type 1 urgent law, that means that it will have to be resubmitted into the regular CDMP and the process started within 1 year of enactment. Yawa.
Preamble. We are the Ietséhaienhs of Kahnawake. We are a community within the Ietséhaienhs Nation and the Residency, and as such are Ietséhaienhs who possess a fundamental and inherent right of self-determination given to us by the Creator. As Ietséhaienhs, we have the right to maintain and promote our Ietséhaienhs identity, including our culture, traditions, language, laws, and customs. As Ietséhaienhs, we have the collective right to determine who can and cannot reside amongst us. This right is fundamental to our survival. Our rights as Ietséhaienhs have been affirmed in the Turo Wampum and have been recognized in other treaties we have entered into with foreign governments and in international covenants and declarations, such as the United Nations Declaration on the Rights of Indigenous Peoples. We have consistently and historically asserted both our rights as Ietséhaienhs and the rights set out in our treaties with foreign governments. These rights cannot be extinguished, diminished, or affected without our consent. We have consistently and historically exercised the right to determine who can reside among us. In recent times, we have been compelled to adopt measures that were necessary to ensure our continued survival as a Ietséhaienhs community. This law is another link in the unbroken chain of our historic struggle to survive as Ietséhaienhs of Kahnawake. This law is the result of a lengthy period of discussion and consultation within our community. It is an expression of the will of the Ietséhaienhs of Kahnawake and is intended to reflect our values and principles. This law is an affirmation of our Ietséhaienhs and treaty rights. This law is essential if we are to survive and to thrive as Ietséhaienhs peoples and as the Ietséhaienhs of Kahnawake. The rights on which this law is based are collective rights belonging to the Ietséhaienhs of Kahnawake. However, the application of this law will respect the fundamental human rights of all individuals in accordance with the principles of dignity and compassion inherent in Ietséhaienhs culture, values, and traditional law. This law is not intended to take away or diminish any and all rights of the people of the Ietséhaienhs Nation or the Residency. This law is a step toward the goal of completely replacing foreign laws and authorities that have been imposed upon us without our consent and toward the restoration of traditional law within Kahnawake. This law is a declaration of our resolve to unite our strengths to achieve this common goal, and by this measure we will strive to ensure the peace and security of future generations of our people and our territories. We recognize that we have been harmed by foreign governments' attempts to undermine our will and ability to survive by dividing our community. We reject the imposition of the Indian Act and of other foreign laws that have presumed to define the principles upon which our community will be determined. We reject all efforts to assimilate and extinguish our community under the guise of absolute individualism. This law represents one of the measures adopted by the community and the Mohawk Council of Kahnawake to regulate residency within the territory of Kahnawake in order to preserve its culture, traditions, and values. Regulating residency is also important because of the limited resources of the community. The community wishes that only those who are on the Kahnawake Registry or who are approved Kahnawake residents have the right to reside on the territory. However, the community is prepared to extend the privilege of temporary residency to others under certain conditions. This law will govern and regulate this privilege. By enacting this law, we are fulfilling our responsibility to defend our community and our nation from an external threat, and in doing so are securing for future generations the right to survive, to continue living proudly as Ietséhaienhs of Kahnawake.
Title. Number 1, the title of this law is the Kahnawake Residency Law.
Purpose, Section 2. This law provides the criteria and procedures for A. The authorization of approved Kahnawake residents. B. The revocation of approved Kahnawake residents. C. The issuance of residency permits, work/education permits, and humanitarian permits. D. The revocation of residency permits, work/education permits, and humanitarian permits. And E. The eviction of those living in the territory who do not have the entitlement or permission to reside under this law.
Definition, Section 3. For the purposes of this law and the regulations, adoption means the legal acceptance of a child of another person's as one's own child. Age of majority means 18 years of age. Applicant means a person who is applying for authorization as an approved Kahnawake resident or who is applying for a permit under this law. Approved Kahnawake resident means a person who has been authorized by the registrar as meeting the criteria provided in this law to be an approved Kahnawake resident, provided the person's authorization has not been revoked. Common law relationship means a conjugal relationship not solemnized by a marriage, ceremony, law, or custom between two persons who live together and publicly refer to themselves as partners or spouses. Community ties means a person's overall participation in community events, volunteer activities, charitable works, and their positive contributions to the Ietséhaienhs of Kahnawake. Complaint means a written submission in accordance with this law and regulations by a Ietséhaienhs of Kahnawake to the compliance officer or the residency registrar. For the purposes of this law, it includes complaints for revocation and complaints for eviction. Complainant, a Ietséhaienhs of Kahnawake who has submitted a complaint to the compliance officer or the residency registrar pursuant to this law. Compliance officer means the person appointed to that position in accordance with the provisions of this law and its regulations, as well as anyone who replaces the compliance officer while they are on temporary leave of absence or if they must recuse themselves because of a conflict of interest. Criminality means A. Having been convicted in Canada of an offence under the Act of Parliament punishable by way of indictment or of two offences under any Act of Parliament not arising out of a single occurrence. B. Having been convicted outside Canada of an offence that is committed in Canada would constitute an indictable offence under an Act of Parliament or of two offences not arising out of a single occurrence that, if committed in Canada, would constitute offences under an Act of Parliament. C. Committing an act outside Canada that is an offence in the place where it was committed and that, if committed in Canada, would constitute an indictable offence under an Act of Parliament. Or D. Committing on entering Canada an offence under the Act of Parliament prescribed by regulations, but does not include any offence which the Mohawk Council of Kahnawake has publicly declared not to be an offence in the territory, nor does it include any offence related to an industry carried out in the territory over which the Mohawk Council of Kahnawake has assumed jurisdiction and is regulating said industry, but which would constitute an offence in Canada or a province. Dependent person means a person who has reached the age of majority but who, as the result of physical or mental limitations, requires mandated care to maintain their quality of life. Guardian means any person who is under a legal duty to provide for a minor or dependent person. Humanitarian permit means the permit issued by the residency registrar authorizing a person who meets the humanitarian permit criteria under this law to reside on the territory. Ya Ungwehunwe Dega means a person who has no Kahnawake lineage or Ungwehunwe ancestry. Immediate family means spouse, sibling, parent, child, step-parent, stepchild, grandparent, grandchild, aunt, uncle, niece, nephew, or first cousin. Justice means a justice of the peace of the Court of Kahnawake or any other judge appointed pursuant to the Kahnawake Justice Act or its regulations, but excludes an appeal judge appointed pursuant to that act. Kahnawake Kahnawa Registry means the list of Kahnawa of Kahnawake maintained by the registrar in accordance with the Kahnawa of Kahnawake law, and for greater certainty does not mean any similar list kept by Canada or any other government. Kahnawa of Kahnawake means a person recognized as a Kahnawa of Kahnawake according to the criteria and procedures in the Kahnawa of Kahnawake law and the regulations. Kahnawa of Kahnawake great-grandparent means a great-grandparent who was or is recognized as Asana Kahnawa at minimum pursuant to the regulation concerning the custom code method of calculation for Kahnawa lineage. Kahnawa lineage means direct descent from Kahnawa great-grandparents to a maximum amount of generations as required pursuant to the regulation concerning the custom code method of calculation for Kahnawa lineage, verified by proof acceptable to the registrar and, if necessary, by the administrative tribunal, the Court of Kahnawake, or the Court of Appeal, as the case may be. Kahnawa territory of Kahnawake, or territory, means A. The lands under the control and jurisdiction of the Kahnawa of Kahnawake, including the Kahnawake interest in Jowirodu, Doncaster. B. Any and all lands that may be added to the lands now under the control and jurisdiction of the Kahnawa of Kahnawake through the negotiation and resolution of land grievances. C. Any and all lands that may be added to the lands now under the control and jurisdiction of the Kahnawa of Kahnawake as a result of any other means. And D. Lands which are returned to Kahnawake as lands within the meaning of subsection 9124 of the Constitution Act 1867. Marriage means a binding union between two consenting persons with legal capacity that is solemnized by ceremony, law, or custom that gives a rise to duties and responsibilities that are enforceable in law. Minor means a person who has yet reached the age of majority. Notice of eviction means a written notice to a person residing on the territory indicating that they will be evicted from the territory. Notice of revocation means a written notice to a person indicating that their privilege to reside in Kahnawake has been revoked. Objection means a written submission pursuant to this law and regulations by a Kahnawa of Kahnawake to the residency registrar contesting the issuance of a permit or the authorization to be an approved Kahnawake resident. Objector: a Kahnawa of Kahnawake who has submitted an objection to the residency registrar pursuant to this law. Ungwehunwe, for the purposes of this law, means a person of indigenous nation of what is currently known as Canada and the continental United States of America, including the Inuit. Ungwehunwe ancestry means direct descent from at least two great-grandparents who are recognized as Asana Ungwehunwe at minimum pursuant to the regulation concerning the custom code method of calculation for Kahnawa lineage, verified by proof of acceptable to the registrar and, if necessary, by the administrative tribunal, the Court of Kahnawake, or the Kahnawake Court of Appeal, as the case may be. Ordinarily resident means that a person maintains their permanent home in Kahnawake and includes persons who may be absent for a period of time but who return to Kahnawake on a regular basis from their place of employment, training, or schooling, and also includes persons who do not reside in Kahnawake due to housing shortages. Organized criminality means A. Being a member of an organization that is believed on reasonable grounds to be or to have been engaged in activity that is part of a pattern of criminal activity planned and organized by a number of persons acting in concert in furtherance of the commission of an offense punishable under an act of Parliament by way of indictment, or in furtherance of the commission of an offense outside Canada that, if committed in Canada, would constitute such an offense, or engaging in activity that is part of such a pattern, or B, engaging in the context of transnational crime in activities such as people smuggling, trafficking in persons, or laundering of money or other proceeds of crime. Permit means a written document issued by the residency registrar authorizing a person to reside on the territory for the purposes of this law. It includes the residency permit, the work education permit, and the humanitarian permit. Raised in the community means a person who has from a young age resided and has spent more than half their lives on the territory. Regulation means any regulation enacted pursuant to this law by the Mohawk Council of Kahnawake. Reside or residency means one of the places where one ordinarily lives or has their home. Residency permit means the permit issued by the residency registrar authorizing a person who meets the residency permit criteria to reside on the territory. Residency registrar means the person appointed to that position in accordance with the provisions of this law and its regulations, as well as anyone who replaces the residency registrar while they are on temporary leave of absence, or if they must recuse themselves because of conflict of interest. Permit holder means a person who has been issued a permit by the residency registrar which has been expired or been revoked. Has not expired or been revoked. Work education permit means the permit issued by the residency registrar authorizing a person who meets the work education permit criteria under this law to reside on the territory.
Entitlement to reside, Section 4. Only Ietséhaienhs of Kahnawake have the entitlement to reside on the territory, provided that entitlement has not been revoked under Section 15 of the Ietséhaienhs of Kahnawake law.
Permission to reside, Section 5. Any person who does not have an entitlement to reside pursuant to Section 4 must file an application for approved Kahnawake resident authorization or for a permit. Section 6. Being authorized as an approved Kahnawake resident or being issued a permit provides while the authorization or permit is valid, a permission to reside on the territory, but does not create any other right to entitlements or services and may be limited by Kahnawake laws, regulation, and policy.
Residency Registrar. Section 7. Upon the enactment of this law, the Mohawk Council of Kahnawake will, after posting the position, appoint a qualified Ietséhaienhs of Kahnawake who meets the specified criteria to be the residency registrar for the purposes of this law. Section 8. The residency registrar may be the same person as the Ietséhaienhs of Kahnawake registrar. Section 9. The residency registrar's appointment will be effective until A. It is revoked with cause by the Mohawk Council of Kahnawake. B. The residency registrar resigns, or C. The residency registrar for any reason is unable to perform their duties under this law. Section 10. The residency registrar will A. Verify and authorize, pursuant to this law, approved Kahnawake residents. B. Verify and decide applications for permits. C. Decide the merits of a complaint for revocation of authorization of an approved Kahnawake resident or a permit. And D. Administer and implement any procedure, process, or policy required to give effect to Section 10, paragraph A, B, and C of this law. Section 11. The residency registrar will at all times A. Respect the principles of fairness, dignity of person, and compassion that are consistent with the traditions and customs of the Ietséhaienhs of Kahnawake. B. Ensure that all information in their possession is held in confidence and is not divulged, discussed, or released to any person or authority except with the permission of the person to whom the information relates. as required to verify a person's residency, as may be required by access to information laws applicable within the territory or in accordance with this law and regulations. And C, ensure the information contained in the permit list and the approved Kahnawake list is safeguarded from loss, destruction, tampering, and unauthorized use. Section 12. The residency registrar will make available for the review of a Kahnawake of Kahnawake during normal business hours the names of those who have been authorized as approved Kahnawake residents or those who have been issued permits. Section 13. The residency registrar will make available for the review by a Kahnawake of Kahnawake during normal business hours the names of those who have had their authorization as approved Kahnawake residents or permits revoked, or those who have been evicted from the territory or who have had an eviction order issued against them.
Compliance Officer, Section 14. Upon the enactment of this law, the Mohawk Council of Kahnawake will, after posting the position, appoint a qualified Ungwehungwe who meets the specified criteria to be the compliance officer for the purposes of this law. Section 15. The compliance officer's appointment will be effective until A, it is revoked by the Mohawk Council of Kahnawake, B, the compliance officer resigns, or C, the compliance officer for any reason is unable to perform their duties under this law. Section 16. The compliance officer will A, when requested by the residency registrar, investigate and verify the factual basis of complaints to revoke approved Kahnawake residents. B, when requested by the residency registrar, to investigate and verify the factual basis of complaints to revoke permits. C, investigate, verify, and decide the merits of complaints for eviction. And D, administer and implement any procedure, process, or policy required to give effect to Section 16C of this law. Section 17. The compliance officer will at all times A, respect the principles of fairness, dignity of the person, and compassion that are consistent with traditions and customs of Ietséhaienhs of Kahnawake. B, ensure that all information in his or her possession is held in confidence and is not divulged, discussed, or released to any person or authority except with the permission of the person to whom the information relates, as required to verify a person's residency as may be required by access to information laws applicable within the territory or in accordance with this law and regulation. And C, ensure that all information in his or her possession is safeguarded from loss, destruction, tampering, and unauthorized use.
Community Review Board, Section 18. There is hereby established a body to be known as the Community Review Board, empowered by the Mohawk Council of Kahnawake through the enactment of this law. Section 19. The Community Review Board may be the same board as the one established under the Ietséhaienhs of Kahnawake law. Section 20. The residency registrar or the compliance officer's decisions which are subject to review pursuant to this law may be reviewed by the Community Review Board on an interim basis until such time as the administrative tribunal is operational pursuant to the Kahnawake Justice Act. Section 21. The Community Review Board will consist of 5 members selected in accordance with the procedures set out in the regulations. Section 22. The Community Review Board may quash, confirm, or vary the contested decision and, if appropriate, make the decision which, in its opinion, should have been made initially. Section 23. The Community Review Board, in performing its duties, conducting its meetings, and making its decisions, will respect the principles of fairness, dignity of person, compassion, and consensus that are consistent with the traditions and customs of the Ietséhaienhs of Kahnawake. Section 24. The members of the Community Review Board will be remunerated for their services in an amount to be fixed by the Mohawk Council Executive Directive. Section 25. MCK Justice Services will fund the Community Review Board. The Community Review Board will submit to MCK Justice Services an annual budget for its approval. Section 26. The Community Review Board will create and maintain a record of its proceedings, any decisions it makes, and the reasons for its decisions.
Approved Kahnawake resident. Application to be an approved Kahnawake resident. Section 27. A person who is not recognized as a Kahnawake of Kahnawake, but who meets the criteria to be an approved Kahnawake resident, must apply to the residency registrar to be authorized as an approved Kahnawake resident within 30 days of residing on the territory. Section 28. Section 27 applicants who are residing on the territory when the law is enacted will have 1 year from the date of this section coming into force to apply for this authorization. During this year, the application fee will be waived. Section 29. A person whose name was on the non-member resident list as defined in the Kahnawake membership law immediately before the coming into force of this law does not have to apply to the residency registrar to be an approved Kahnawake resident. These persons will automatically have their names placed on the approved Kahnawake resident list.
Eligibility to be an approved Kahnawake resident. Section 30. The following are eligible to be authorized as an approved Kahnawake resident. A person who has 3 Kahnawake of Kahnawake great-grandparents and has immediate family and community ties. B, a person who has 2 Kahnawake of Kahnawake great-grandparents, has immediate family, community ties, and who was raised in the community. C, a person with Ietséhaienhs ancestry who was adopted as a minor by a Kahnawake of Kahnawake after November 10, 2003, and has immediate family and community ties, and who was or is being raised in the community. Or D, Ietséhaienhs who was married to a Kahnawake of Kahnawake or someone eligible to be a Kahnawake of Kahnawake prior to the 1981 moratorium and is still married and residing with that spouse, or is still residing and was widowed while residing in the territory. E, a minor who was adopted by a Kahnawake of Kahnawake prior to November 2003 and who has reached the age of majority.
Approved Kahnawake resident list. Section 31. Except as otherwise provided for in this law or its regulations, the residency registrar will keep a confidential list of the names of those persons who have been authorized to be approved Kahnawake residents. This law will be updated by the residency registrar as required by this law. This list will be updated by the residency registrar as required by this law and the regulations. Section 32. Once a person is authorized as an approved Kahnawake resident, their name will remain on the approved Kahnawake resident list until such a time as A, they request to have their name removed, B, their authorization as an approved Kahnawake resident is revoked pursuant to this law, or C, they are deceased as evidenced by proof acceptable to the residency registrar, at which point the residency registrar will remove that person's name from the approved Kahnawake resident list.
Permits. General. Section 33. A person who is not recognized as a Kahnawake of Kahnawake or authorized as an approved Kahnawake resident who wishes to reside within the territory must apply for a permit from the residency registrar within 30 days of residing on the territory. Section 34. A permit holder may apply for a renewal of their current permit or apply for a different permit.
Residency permit. Section 35. In order to be eligible for a residency permit, the applicant must meet one of the following criteria as verified by proof acceptable to the residency registrar. A person who has Ietséhaienhs ancestry and 1, is married or living in a common law relationship with a Kahnawake of Kahnawake, or 2, has immediate family and community ties. B, a person who has sufficient knowledge of the Kahnawake language and Kahnawake culture, as of evidenced by the results of a language and culture test taken in accordance with the regulations on language and culture testing, and has immediate family and community ties. Section 36, a residency permit is valid for 3 years.
Work/education permit. Section 37. In order to be eligible for a work/education permit, the applicant must meet the following criteria as verified by proof acceptable to the residency registrar. A person who has Ietséhaienhs ancestry and 1, is working within the territory, or 2, is attending an educational facility within proximity to the territory. Section 38. Work/education permits will be valid for a minimum of 1 year. If the duration of the applicant's work or education is significantly less than 1 year, The residency registrar may issue a work/education permit for less than 1 year.
Humanitarian permit, Section 39. In order to be eligible for a humanitarian permit, the applicant must meet one of the following criteria as verified by proof acceptable to the residency registrar. A. Be terminally ill and need assistance or lodging from an immediate family member who is Kahnawà of Kahnawake who resides on the territory. B. Be providing assistance to a Kahnawà of Kahnawake who is terminally ill. C. Providing assistance to a Kahnawà of Kahnawake who has a disability or illness which requires specialized care. Section 40. The residency registrar will determine the length of each humanitarian permit to a maximum of 1 year.
Renewal of permits, Section 41. Any permit holder who wants to continue to reside on the territory beyond the expiration date of their current permit must reapply 30 days prior to the expiration date. Section 42. Any application for permit renewal which is filed within 10 days before the expiration date is subject to additional administration fees. Section 43. A permit holder will only have the permission to reside on the territory while the residency registrar is deciding on the renewal of the permit. If the permit holder has submitted the request for renewal prior to the expiration date of their permit, and any delays in renewing the permit which extend past the expiration date are due to the residency registrar. Section 44. If an application for permit renewal is filed after the expiration date of the permit, the application will be refused and the applicant will have to submit an application for a new permit. Section 45. The residency registrar must review the application for renewal and provide the applicant and the compliance officer with a written decision within 30 days of receiving the application. Section 46. The permit holder has 30 days to request a review of the decision of the residency registrar. Section 47. If the residency registrar does not renew the permit, notice of the non-renewal will be given to the compliance officer who must send the person in question a notice of eviction within 5 working days of receipt of the residency registrar's decision.
New permit applications, Section 48. Every 6 years, the permit holder must reapply for a new permit and may not proceed by the renewal process. The 6-year period begins at the time the permit holder is issued their first permit.
Expired permits, Section 49. Once a permit expires, if the permit holder has not applied for a renewal or reapplied for a new permit, the residency registrar must inform the compliance officer of the expired permit. Section 50. The compliance officer must send a notice informing the person in question to file a new application within 30 days or no longer reside on the territory. Section 51. If the person in question continues to reside on the territory after the 30 days notice, the compliance officer must issue the person a notice of eviction.
Permit list, Section 52. The residency registrar will keep a list of the names, addresses, and telephone numbers of those persons who have been issued a residency permit, a work education permit, or a humanitarian permit. This list will be updated by the residency registrar as required by this law and the regulations. 53. Once a person is issued a permit, they will remain on the permit list until such a time as A. Their permit expires and has not been renewed, B. Their permit is revoked pursuant to this law, or C. They are deceased as evidenced by proof acceptable to the residency registrar, at which point the residency registrar will remove their name from the permit list.
Application process for authorization as an approved Kahnawake resident and for permits. General, Section 54. Any person may, in the best interest of a dependent person, apply on that person's behalf. Section 55. Complete applications must include A. Signed and completed application form, B. A criminal background check, C. A recent passport-sized photo, D. The application fee is determined by the regulations, E. An indication of whether the application is for an approved Kahnawake resident or for a permit, and in the case of a permit, the type of permit being requested, F. Results from the language and culture test where applicable, G, the name and birth date of every minor who will be residing with the applicant and over whom the applicant has parental authority. H, any other information and documents required by the regulations. Section 56, dependent persons are exempt from the language and culture test and the criminal background check. Section 57, incomplete applications will be declined. The applicant may submit another application at any time, but will be required to resubmit all the documents and information listed in Section 55, including a subsequent application fee.
Verification and decision. Section 58. The residency registrar will, within 10 days of receipt of an application, similarly reject any application which A, is incomplete, B, does not comply with the requirements set forth in the law and the regulations, C, could not be successful because the applicant clearly does not possess the criteria necessary to be granted approved Kahnawake residency authorization or the permit for which they have applied. Section 59. If the applicant is summarily dismissed, the residency
application.
registrar will provide written reasons to the applicant and compliance officer. If the application is summarily dismissed, the compliance officer must send a notice of eviction to the applicant if the applicant is residing on the territory. Section 61, the applicant has 30 days to request a review of the decision of the residency registrar.
Public notice of application, section 62. If the application is not summarily dismissed, the residency registrar will place a public notice of the application for authorization to be an approved Kahnawake resident or of the application for any permit under this law. Section 63. The public notice must include A, the name of the applicant, B, the number of minors or dependent persons that will be residing with the applicant, C, the name of the applicant's parents or affiliation to Kahnawake, D, the section of this law under which the applicant submitted their application, and E, the deadline to receive written objections concerning the application. Section 64. The public notice must be posted for 30 days. Section 65. The deadline to receive written objections will be the last day of the public notice.
Objections to approved Kahnawake residence applications and permit applications. Section 66. Within 30 days of the last day of the
We're missing one.
objections may only be made by Ietséhaienhs of Kahnawake. Section 67. Within 30 days of the last day of the public notice, the residency registrar must determine whether the objection is admissible. Section 68. In order for an objection to be considered admissible by the residency registrar, the objection must be A, factually based, B, in writing or transcribed, C, sworn or solemnly affirmed and signed by the objector, D, in accordance with the law and regulations, E, related to one of the criteria for ineligibility under Section 76 or one of the criteria listed in the section under which the applicant is applying, and F, evidence by proof acceptable by the residency registrar. Section 69. Within 5 working days of determining that an objection is admissible, the residency registrar must provide a written notice to the applicant indicating the deadline mentioned in Section 70 for the applicant to provide any written representations or additional evidence with a copy of the objection submitted. Section 70. The applicant will have 10 working days to respond in writing to the objection or to provide any additional evidence. Section 71. If the residency registrar determines that there is sensitive information on the objection form, they may redact sections of this form prior to providing the copy to the applicant. The redacted sections of the objection form must not include the name of the objector or any substantive information required by the applicant in order to adequately respond to the objection. Section 72. If the residency registrar determines that the objection is not admissible, the residency registrar must provide a written decision with reasons to the objector and the applicant within 30 days of receiving the objection. Section 73. The decision rejecting an objection is not admissible is final and is not subject to appeal.
Applicant interview, Section 74. In considering an application, the residency registrar may require a meeting with the applicant, an objector, or any other person to answer questions relevant to the application. Section 75. The interview mentioned in Section 74 will be conducted in accordance with the process chosen by the residency registrar. The applicant, the objector, or other persons will be informed of the process prior to the interview.
Ineligibility, Section 76. An applicant may be deemed ineligible and their application may be denied if the applicant, A, has through an act or omission directly or indirectly contravened a provision of this law, B, is a danger to the community, C, has been involved in criminality or organized criminality, D, has directly or indirectly misrepresented themselves or withheld material facts relating to a matter relevant to this law, E, has committed a material breach of Mohawk law, tradition, or custom. F, for a residency permit, does not possess sufficient knowledge of Kahnawake language and Kahnawake culture as evidenced by the results of a language and culture test taken in accordance with the regulation on language and culture testing.
Final decision on the application. Section 77. In considering an application, the residency registrar must review all relevant materials, including any admissible objections and responses thereto from the applicant. Section 78. The residency registrar must provide the applicant and the compliance officer with a written decision regarding the merits of the application within 60 days of the last day of public notice. Section 79. If the residency registrar denies the application, the compliance officer must send the applicant a notice of eviction within 5 working days of receipt of the residency registrar's decision. Section 80. If admissible objections were made, the residency registrar must also provide the objectors with the written decision within 60 days of the expiration of the public notice. Section 81. The written decision of the residency registrar must provide detailed reasons for approving or denying the application. Section 82. In a written decision approving an application, the residency registrar must provide the applicant with the list of obligations for approved Kahnawake residents/permit holders. Section 83. Once the applicant has sworn or solemnly affirmed the oath of respect, the residency registrar will provide the applicant with the permit or the approved Kahnawake resident authorization and will put their name on the permit list or the approved Kahnawake resident list.
Obligations of approved Kahnawake residents and permit holders. Section 84. All approved Kahnawake residents and permit holders are obliged to A, comply with the codes, laws, and regulations applicable in Mohawk territory of Kahnawake. B, respect and protect Mother Earth. C, respect and encourage Kahnawake and Kahnawake culture. And D, update the residency registrar regarding any changes to the information provided in the application.
Oath of respect, Section 85. Prior to being issued a new permit or authorized as an approved Kahnawake resident, the applicant must swear or solemnly affirm an oath of respect in the form provided in the regulations, affirming that they will respect the obligations of permit holders, approved Kahnawake resident, unless the person is a dependent person.
Revocation of residency. Grounds for revocation. Section 86. A permit or approved Kahnawake resident authorization may be revoked if the person A, has through an act or omission directly or indirectly contravened a provision of this law, B, is a danger to the community, C, has been involved in criminality or organized criminality, D, has directly or indirectly misrepresented themselves or withheld material facts relating to a matter relevant to this law, E, has committed a material breach of Mohawk law, tradition, or custom, or F, allows a person to reside on the territory who does not have an entitlement to reside pursuant to Section 4 of the law, or is not an approved Kahnawake resident, or does not have a valid permit.
Procedure for revoking a permit or approved Kahnawake resident authorization. Section 87. A Kahnawake of Kahnawake may submit a complaint to the residency registrar pursuant to this law if they know of a permit holder or of an approved Kahnawake resident who has or is in breach of Section 86 or of a criteria under which they applied. Section 88. Within 30 days of receiving a complaint, the residency registrar must determine whether it is admissible. Section 89. In order for a complaint to be considered admissible by the residency registrar, the complaint must be A, factually based, B, in writing or transcribed, C, sworn or solemnly affirmed and signed by the complainant, D, in accordance with the law and regulations, E, related to one of the criteria under which the person had applied or the criteria for revocation under Section 86 of this law, and F, supported by evidence. Section 90. Within 5 working days of determining that the complaint is admissible, the residency registrar must provide a written notice to the permit holder or the approved Kahnawake resident, informing them of the deadline mentioned in Section 91 to provide any written representations or additional evidence, and with a copy of the complaint submitted. Section 91. The permit holder or the approved Kahnawake resident will have 10 working days to respond in writing to the complaint or to provide any additional evidence. Section 92. If the residency registrar determines that there is sensitive information on the complaint form, they may redact sections of this form prior to providing the copy to the permit holder or the approved Kahnawake resident. The redacted sections of the complaint form must not include information required by the permit holder or approved Kahnawake resident in order to adequately respond to the complaint. Section 93. If the residency registrar determines that the complaint is not admissible, the residency registrar must provide a written decision to the complainant and the permit holder or the approved Kahnawake resident within 30 days of receiving the complaint with reasons for the decision. Section 94. The decision rejecting a complaint is final and is not subject to appeal.
Final decision on revocation. Section 95. Prior to making a final decision on the merits of the revocation, the residency registrar must review all relevant material presented by the complainant and the permit holder or approved Kahnawake resident, and may also request additional relevant information, including requesting an interview with the complainant, the permit holder, approved Kahnawake resident, or any other person. Section 96. Within 30 days of the decision on the admissibility of the complaint, the residency registrar must provide the complainant and the permit holder or approved Kahnawake resident with a written decision which must include detailed reasons for maintaining or revoking the permit holder's permit or the approved Kahnawake resident's authorization to reside on the territory. Section 97. If the residency registrar has decided to revoke the permit or the approved Kahnawake resident authorization to reside on the territory, the residency registrar must include and send a notice of revocation, including the date of revocation, to the permit holder or the approved Kahnawake resident and the compliance officer. Section 98. The permit holder, approved Kahnawake resident, or complainant have 30 days to request a review of the residency registrar's decision. Section 99. The compliance officer must send the person whose permit or authorization has been revoked a notice of eviction within 5 working days of receipt of the residency registrar's decision. Section 100. The residency registrar must remove the name of the person who has been revoked from the permit list or the approved Kahnawake resident list on the date of revocation indicated on the notice of revocation.
Eviction, General, Section 101. Anyone residing on the territory who does not have an entitlement to reside pursuant to Section 4 of this law, is not an approved Kahnawake resident, or does not have a valid permit may be subject to an eviction order.
Complaint for eviction. Section 102. A Ietséhaienhs of Kahnawake may submit a complaint for eviction to the compliance officer in accordance with this law. If they know of somebody residing in the territory who does not have an entitlement to reside under Section 4 of this law, is not an approved Kahnawake resident, or does not have a valid permit. Section 103. Upon receiving a complaint, the compliance officer must provide a written notice to the person in question with a copy of the complaint submitted and of the deadline for the person in question to provide any written representations or additional evidence. Section 104. If the compliance officer determines that there is sensitive information on the complaint form, they may redact sections of this form prior to providing a copy to the person in question. The redacted sections of the complaint form must not include the name of the objector or any substantial information required by the person in order to adequately respond to the complaint. Section 105. The written notice in Section 103 must also inform the person of their right to apply for a permit or for authorization to be approved Kahnawake resident, or for recognition as a Kahnawake of Kahnawake within 10 working days. Section 106. The person will have 10 working days from the receipt of the notice to respond in writing to the complaint or to provide any additional evidence to the compliance officer. Section 107. If the person applies for a permit for authorization as an approved Kahnawake resident or for recognition as a Kahnawake of Kahnawake within 10 working days of receiving the written notice in Section 103, the compliance officer will close the file and inform the person and the complainant that the file will proceed by the application process and be decided by the residency registrar. Section 108. If the person has not applied for a permit for authorization as an approved Kahnawake resident or for recognition as a Kahnawake of Kahnawake within 10 working days of receiving the written notice in Section 103, the compliance officer must determine whether the complaint is admissible. Section 109. In order for a complaint to be considered admissible by the compliance officer, the complaint must be A, factually based, B, in writing or transcribed, C, sworn or solemnly affirmed and signed by the complainant, D, in accordance with the law and regulations, E, related to one of the criteria for eviction under Section 101, F, supported by evidence. 110. The compliance officer determines that the complaint is not admissible. If the compliance officer determines that the complaint is not admissible, they must provide a written decision to the complainant within 30 days of receiving the complaint. Section 111. The compliance officer's decision in Section 110 is final and without appeal. Section 112. If the compliance officer has decided that the complaint is admissible and the person does not have the entitlement or permission to reside on the territory, the compliance officer must enclose with their reasons for decision a notice of eviction. Section 113. The person who is subject of a notice of eviction has 30 days to request a review of the compliance officer's decision in Section 112.
Notice of eviction. Section 114. A notice of eviction must be delivered by hand and to the person in question and must include A, the name of the person being evicted, B, written reasons for the eviction, C, the date the person must leave the territory, D, the date, time, and place when an eviction order will be sought before a justice and the person's right to be present and be heard, and E, any other information as required by this law and regulations. Section 115. The compliance officer must send a copy of any notice of eviction or any decision of the Community Review Board or Justice upholding of revocation or a notice of eviction to MCK Justice Services. Section 116. If applicable, the compliance officer must send a copy of the notice of eviction to the landlord who is renting the property to the person who has received a notice of eviction.
Eviction orders. Section 117. The justice has the authority to issue an eviction order against any person who has received a notice of eviction and to award costs for the execution of the eviction order. Section 118. The decision of the justice may be appealed to the Kahnawake Court of Appeal. Section 119. The person against whom the eviction order is made must be served with a copy of the eviction order when it is made. Section 120. The eviction order comes into force the day the eviction order is issued. Section 121. Once the eviction order is issued, the person against whom it is issued must leave the territory and take all of their movable property within 10 working days. Section 122. Any movable property which has not been removed prior to the enforcement of the eviction order is deemed to have been abandoned. Section 123. If the person against whom an eviction order has been issued has not left the territory within 10 working days, a bailiff has the authority to remove the person. Section 124. In executing the eviction order, the bailiff has the right to enter onto private property and remove the person and/or their movable property. Section 125. Movable property which is not exempt from seizure may be sold to pay for any costs related to the eviction. Section 126. The removal of a person from the territory in accordance with an eviction order must be temporarily stayed if A. The person is the parent or guardian of one or more children under the age of 6 who reside with the person, and B. The decision to remove the person is issued between November 1st and April 1st.
Review of decisions of the residency registrar or the compliance officer. Section 127. The Community Review Board shall review and determine whether due process was followed, whether laws of natural justice were adhered to, ensure absence of bias, ensure the decision was reasonable, determine whether there was an absence of jurisdiction, or if there was a mistake of law. Section 128. The Community Review Board may quash, confirm, or vary the contested decision, and if appropriate, make the decision which, in its opinion, should have been made initially. Section 129. Proceedings for review are brought before the Community Review Board by submitting a completed application with a copy of the decision within 30 days of receiving the written decision. Section 130. The application must state the reason for the application, the conclusions sought, and any other information required by this law and regulations. Section 131. The administrative assistant of the Community Review Board must send a copy of the application to the other implicated parties who may respond to it in writing within 30 days of receiving the application. Section 132. The Community Review Board will proceed on the basis of the record. It may, however, if it considers it appropriate or if a party requests it, hear the parties. Section 133. A properly initiated review stays execution of the decision on review.
Appeal of decisions of the Community Review Board. Section 134. Decisions rendered by the Community Review Board may be appealed to the Justice on an interim basis in accordance with this law, until such time as the Court of Kahnawake is operational pursuant to the Kahnawake Justice Act. Proceedings for appeal are brought before the Justice by submitting a completed application with a copy of the decision within 30 days of receiving the written decision. Section 135. The application must state the grounds invoked in support of the application, the conclusion sought, and must contain any other information required by this law and regulation. Section 136. The court clerk must send a copy of the application to the other parties who may respond to it in writing within 30 days of receiving it. Section 137. The Justice will proceed on the basis of the evidence presented before the Community Review Board. Section 138. No appeal lies from the decision of the Justice. Section 139. A properly initiated appeal stays execution of the decision on appeal.
Penalties, Section 140. Anyone who A. knowingly provides residency to someone who does not have an entitlement to reside pursuant to Section 4 of the law, or is not an approved Kahnawake resident, or does not have a valid permit, or B. illegally resides on the territory, or C. does not respect an eviction order, is guilty of an offense and shall be liable on summary conviction to 1. a minimum fine of $400 for the first offense, 2. a minimum fine of $800 for the second offense, and 3. a minimum fine of $1,000 for each subsequent offense. Section 141. Every day a person is in contravention of this law constitutes a separate offense.
Enforcement. Section 142. The Kahnawake Peacekeepers have the sole and exclusive authority to enforce this law. Section 143. The Justice has sole and exclusive jurisdiction to hear and decide all matters related to this law until such a time as the Court of Kahnawake is operational under the Kahnawake Justice Act. Section 144. If the Justice finds any section of this law to be invalid, the decision does not render this law invalid in its entirety.
General provisions, right to counsel. Section 145. All parties have the right to legal counsel before the Community Review Board and the Justice.
Extension of timelines by the registrar. Section 146. The residency registrar or compliance officer may decide to extend any of the time periods or deadlines set out in this law or the regulations if they are convinced that it is in the interest of fairness to do so. Section 147. When there is a change to the time periods or deadlines, a written notice must be provided to the parties prior to the date mentioned in the original notice, informing them of the change.
Publication of decisions. Section 148. The following must be published within 5 working days of the decision. A decision to proceed with an application following the verification of the information by the residency registrar. B, a decision granting a permit or authorization as an approved Kahnawake resident. And C, a decision renewing a permit. Section 149. The publication must include the following information. A, the decision. B, the name of the applicant, approved Kahnawake resident or permit holder. C, the section under which they applied and were granted their authorization or permit. And D, in the case of permits, the expiration date of the permit.
Annual reports to council, section 150. On or before January 31st of each year, the residency registrar must provide the Mohawk Council of Kahnawake with a written report listing all persons residing in the territory as approved Kahnawake residents, as well as a list of all persons who have been issued a permit, including the category of permit and the expiry date, and the identity of any applicants whose applications have been declined. Section 151. On or before January 31st of each year, the residency registrar must provide the Mohawk Council of Kahnawake with written report listing all revoked approved Kahnawake residents, as well as a list of all persons whose permits have been revoked. Section 152. On or before January 31st, the compliance officer must provide the Mohawk Council of Kahnawake with a written report listing all those persons who have been evicted.
Written notice, section 153. Unless otherwise stated in this law, any notices or decisions required by this law or the regulations will be sent by registered mail, and for all purposes of this law and the regulations, be deemed to have been received on the date the recipient signs for it. Section 154. In the event a notice cannot be sent by registered mail, or the recipient fails or refuses to sign for it within 15 working days from the date on which the registered mail was sent, the residency registrar, compliance officer, community review board, or the justice may direct that the required notice be given by bailiff.
Regulations, section 155. The Mohawk Council of Kahnawake may, by Mohawk Council Executive Directive, enact the regulations necessary for the implementation of this law, including A, the procedure for considering and deciding an application for a permit. B, the procedure, content, and form of the language and culture testing. C, the procedure for considering and deciding an application for approved Kahnawake resident. D, the procedure for considering and deciding a complaint for revocation or for eviction. E, the form and content of the oath of respect. F, the fee for approval for approved Kahnawake residents and permit application. And G, such other regulations that may be necessary to implement the provisions of this law. Section 156, the Mohawk Council of Kahnawake may consult with the residency registrar and or the compliance officer before enacting regulations. Section 157, copies of all regulations enacted by the Mohawk Council of Kahnawake will be provided to the residency registrar and compliance officer and will be made available at the Ietséhaienhs of Kahnawake, approved Kahnawake residents, and to permit holders.
Amendments, section 158. This law may be amended in accordance with the procedure set forth in the community decision-making process or any other process which may replace it.
Enactment and coming into force, section 159. Further, to the will of the Ietséhaienhs of Kahnawake, this law is enacted on such a date with the MCR number and the date that the law will come into force.
Okay, so now the certification of the process will be signed by members of the Technical Drafting Committee. So in the matter of the creation of the Kahnawake Residency Law, we, the Technical Drafting Committee, being comprised of the portfolio chief and technicians and confirmed by the coordinator of the Kahnawake Legislative Coordinating Commission, do hereby certify the following. 1. This law, Kahnawake Residency Law, received a community mandate for its development on May 23, 2017 in Kahnawake. 2. The community mandate identified the draft law's purpose and scope as being purpose. The residency law establishes a system to control the residency of non-members within Kahnawake. Residency is a privilege of temporary residency to non-members who meet the criteria in the law. Scope defines the eligibility criteria for non-member residency. Gives the authority to hear, approve, and revoke residency applications and permits. Includes an appeal process. Reasons and processes revocation of residency and ensures enforcement. 3. The final law does faithfully reflect the purpose and scope of the law as contained in the initial mandate received from the community. 4. The development of the final law has in all respects conformed to the community decision-making process. The formal reading is filmed with community members and the local media invited to observe the law being read into the record by members of the technical drafting committee. In witness hereof, we have signed. I will pass this down for all of your signatures. Do you have a pen? Complete. Now,
Next step.
I mentioned the next steps, did I not, earlier on? We will be going to the enactment on Monday, June 17th, after which the law will be distributed among several departments. Then we'll be posting the law online on our website, www.KahnawakeMakingDecisions.com.